All right, outside the presence of the jury, the individual in the gallery was gracious enough to allow the bailiffs to inspect her phone. It took a few moments to have the phone charged so they could inspect it, and they examined the phone, found nothing that would indicate any violation of the rules of this court. So the bailiffs have asked, and I would extend that as a court order, that all electronic devices are to be turned off so that we have no, individuals seated in the gallery, so we have no need to delay proceedings further over a situation like this. With that being said, I believe we're ready to proceed. If you'll bring the jurors in, please. Ladies and gentlemen, I apologize for the delay a bit longer than I'd expected. An administrative matter came up that I needed to attend to outside of your presence, so that has been resolved, and we are now, I believe, ready. Mr. Brown is ready to present the final argument in this case.
Do we kill Travion Smith, or do we condemn him to a lifetime of imprisonment? That is the only question that is left to be decided in this case. There is no longer any doubt that Travion will be punished. Your verdict last week assured that. And there is no doubt that he will be punished harshly and severely. Now you must decide what form that harsh and severe punishment will take. We started talking about the possibility of a penalty phase in this trial during jury selection. And all of you expressed different views about life imprisonment, about the possibility of parole and the death penalty. All of you did say that there would be cases out there where you could consider the death penalty. But each and every one of you also said that you could consider life imprisonment without parole, even for somebody who was convicted of first-degree murder, even for somebody who was convicted of premeditated, deliberate murder done with a specific intent to kill. And each of you also said this, that you could consider mitigating circumstances. Circumstances not just about the crime and the defendant's role in the crime, but about his background, about his character, about his record. I want to spend a few moments talking about the law that you're going to be instructed with in the moments and all, because I know we talked about it in jury selections, and Mr. Waller touched on it, and Judge Ridgway is going to spend time doing it, but it's a complicated process. And it's a process that has such importance in this case. You're going to be given, we had talked about in jury selection about 4 possible issues. There's actually 5 in this case. And the first has to do with the question of exactly, it goes back a little bit to what was discussed at Guilt Innocence, which is exactly Travion's role in this case. And the first question is going to be, do you unanimously find beyond a reasonable doubt whether Travion himself killed the victim, or 2, intended the victim to be killed, 3, intended lethal force to be used, or 4, was a major participant in the underlying felony and showed reckless disregard for human life, reckless indifference to human life. The reason that you're being asked this question is that because of your verdict and because of how the question was asked during Guilt Innocence, we don't know. Nobody knows, because it's only between, we were not there in the discussions, we don't know your verdict, what exactly you found about Travion's role in the killing of Melissa Huggins-Jones. You know that all of us argued about that and presented the evidence last week, and we're not going to go spend our time here going over that. You remember the arguments about that and all. If you found it, you know what you found, and that's the verdict. That part of this question is what controls here. But if you did not find that he himself was the one who did the killing, that he himself did not show that premeditation, deliberation, that specific intent to kill, that he did not intend to kill, then I submit to you that that answer should be no. And if you don't find that unanimously, and if you don't find that beyond a reasonable doubt, the process is over, and Travion will be sentenced to life imprisonment without parole. Assuming if and only if you answer 1A, yes, then you move down to issue number 1. And that's about the existence of aggravating circumstances. And again, you are required to find unanimously and beyond a reasonable doubt the existence of an aggravating circumstance before you can find it. Once you decide what aggravating circumstances exist, the next question for you is going to be the existence of mitigating circumstances. This question, issue 2. And I want to spend a few moments talking about that and that issue and about the law about it. And we're going to get back to what we mean about the law. But in doing that, you're going to get a definition of mitigating circumstances. And I know Ms. Dee talked about it a little bit in her closing, but Judge Ridgway is going to tell you about the definition of mitigating circumstances, and it's things that we talked about in jury selection. It's a group of facts which do not constitute a justification or excuse for a killing or reduce it to a lesser degree of crime than first-degree murder. In other words, the evidence that you heard during this past week is not things that we are saying in any way is an excuse or justification or something that makes it another crime other than first-degree murder. If it was, you would have heard that evidence in the first phase. It is evidence, however, that shows why, when you're choosing between 2 very harsh and severe punishments, why one is more appropriate than the other. Why life imprisonment without parole is the more appropriate punishment in this case. And in doing it, the type of evidence that you heard is exactly the type of evidence that the law says that you can and that you should and you must consider in deciding the sentence. You're going to be told that you can consider any aspect of the defendant's character or record in doing that. You're going to be able to consider his background. And we're going to talk about, Ms. Dees talked about it, and we're going to talk about it again a little bit. But there are things about this, about his life, about his character, that are mitigating, and that should be considered by you in deciding which of these 2 harsh and permanent punishments should be imposed in the case. You know, as you're going to go through, Judge Ridgway is going to instruct you on all the mitigating circumstances in this case. And there are, I believe, 37 or 38 that you can be hearing. about. I want you to listen to it, and you are the ones who decide the evidence and the witnesses and what you should believe happened in that. And sometimes you're going to have to decide between contradictions in the evidence, and we talked about this in the guilt-innocence phase. That's your most important job as a jury. But listen to the instructions that Judge Ridgway hears, and you're going to hear this about actually most of the mitigating circumstances. You're going to hear this language. All of the evidence tends to show. And then talk about a specific mitigating circumstance. Accordingly, in this circumstance, if one or more of you find the facts to be as all the evidence tends to show, you will find that the circumstance has been established, and then you decide whether it has mitigating value. In other words, for most of the circumstances you're going to hear, they are not contradicted by evidence, by witnesses, by anybody. What you heard was uncontradicted. What you heard was true about the backgrounds and things about it. What you heard, there can be disputes about little things, but the heart of what we're saying in this mitigation is uncontradicted because it happened. And it's not doing it. Let's talk a little bit more about this when we talk about mitigation, and keep in mind this other aspect about it.
Mr. Brown, could you keep your voice up so the court reporter could hear you, sir?
I'm sorry. Mitigating circumstances are individual choices. You'll have as a chance as a group to discuss with each of you what you believe the circumstance. What do you believe we've proven the fact? And what do you bring? And what do you believe we've shown that it is mitigating? What do you believe in your head and your heart that it's mitigating? But then when the choice comes down to whether this is a mitigating circumstance that you should consider in this case, that is an individual choice. Each of you decide for yourselves whether or not this is a mitigating circumstance, whether this is a reason that should be considered to spare the life of Travion Smith and instead sentence him to life imprisonment without parole. And each of you decide for yourself whether to consider that mitigating circumstance. So discuss it as a group, but keep that individual choice in the mind when you decide whether or not it exists. You're going to get a list, as we say, of a bunch of mitigating circumstances, but there's one that you need to consider as well. At the very end, the last one you'll be instructed on. You can consider any other circumstances arising from the evidence which you deem to have mitigating value. It's kind of called, we call it catch-all mitigating circumstance. That means is that as lawyers and judges, we don't necessarily get everything that's important in this case and put it on that sheet. There may be things about this case. There may be things about Travion's life. There may be things about the people in this case that you find to be mitigating that is not on that sheet. There may be things on there that you say, that is a reason I want to consider, that I want to hold, to be a reason why somebody should be, why being punished, should not be sentenced to die. And when you find those reasons, and if it moves one or more of you for specific reasons, then the answer to that mitigating circumstance is yes. And that should be a circumstance that you consider, not only in answering issue 2, but in deciding the fate of Travion in this case. Once you decide what mitigating circumstances exist, the next question is the weighing question, the one about which weighs more, the mitigating circumstances or the aggravating circumstances. The question is, and I think Mr. Waller and I agree that it's kind of got this confusing language, but the question is, has the state, basically comes down to, has the state proven beyond a reasonable doubt that the aggravating circumstances outweigh the mitigating circumstances? And in doing that, you take into consideration
You did discuss it as a group, but you take into consideration each of the mitigating circumstances that you individually found. And you give the weight to that individual mitigating circumstances that you felt have been shown and you felt have value, and you weigh it in making a determination. If and only if the state has proven beyond a reasonable doubt and unanimously that the aggravating circumstances outweigh the mitigating circumstances, would you answer that question yes? And then the process would continue. But when you look at the mitigating circumstances, and if you're not convinced beyond a reasonable doubt, if you are not unanimous, then it's your duty and your right to answer that question no. And Travion Smith will be punished. Punished harshly, punished severely, and be punished with life imprisonment without parole. As we said, if and only if you answer that third question, yes, you would move down, you would then look at question number 4. And that has to do with whether the aggravating circumstances are sufficiently substantial to call for the imposition of the death penalty. When considered in light of the mitigating circumstances, when considered in light of the mitigating circumstances that each of you found individually, that each of you believe have some bearing in this case. And when you go ahead and you look at that question, you again have to, before you can answer that question yes, you all have to be convinced unanimously and beyond a reasonable doubt that the state has proven that case, that the only answer, that the death penalty is the only appropriate punishment. They have to prove that beyond a reasonable doubt. But if you're not, if it's not been proven, if you are not unanimous, if you look at it and consider still the mitigating circumstances and everything and don't believe that the death penalty is the appropriate punishment, that Travion Smith should be punished and punished harshly and severely, but you as an individual or as a group believe that the death penalty is not the appropriate punishment, then the answer to that question is no. And then, if you say no, Judge Ridgway will impose sentence. And Travion Smith will be punished. He will be punished harshly. He will be punished severely. But he will be punished appropriately with life imprisonment without parole. In our state and in our country, the death penalty is not appropriate for every case of first-degree murder. It is reserved for the worst of the worst. And when we talk about the worst of the worst, we don't mean just simply the worst of the worst crimes. We are talking about the worst of the worst people. And that's just not Travion. The worst of the worst are those who have killed before, those whose history and everything else shows that if they are not given the ultimate punishment, that they will kill again. Those who have shown no signs of having any redeeming value, or that redemption is not even a possibility. And that is not Travion. The fact is, Travion is not even the worst of the worst when it comes to this tragic and heartbreaking crime. During the first phase of this trial, during closing arguments, Mr. Waller got up and said, Ronald Anthony is a murderer, but so is Travion Smith. And he had an excellent point that he was making about the guilt-innocence phase. Ronald Anthony's actions did not excuse Travion Smith, did not justify what happened. And by your verdict of first-degree murder, you did say that Travion Smith was a murderer. But at sentencing, it is appropriate to compare the roles of the people involved in the case.
Objection.
Overruled.
And it's appropriate to compare the roles and to decide what is the appropriate punishment for Travion Smith. There is nothing that they have shown about Travion Smith's role in this case that is so much worse than Ronald Anthony's role that Travion Smith should get the death penalty instead of another punishment, another harsh punishment, life imprisonment without parole.
Objection from
Sustained.
Motion to strike.
Jury's to disregard the last statement.
There's nothing that you've heard from the witnesses in the case. There's nothing that would suggest that Travion was the most culpable, that Travion was the leader, that Travion was the worst one in this case. What you heard was Ronald Anthony was the older one, that Ronald Anthony was the leader when they were breaking into cars, that Ronald Anthony was the one who arranged for them to get to ride out of North Hills once the murder was complete, and that Ronald Anthony was the one who arranged for the stolen items to be sold. Ronald Anthony's role in this case does not excuse Travion and does not prevent him from getting a harsh and serious punishment
Objection.
like life imprisonment.
Sustained.
In deciding Travion's punishment, you should compare their roles, both of their roles in this case.
Objection.
Overruled.
There's no reason to believe that Travion's role is so much worse than Ronald Anthony's, that the death penalty is the only appropriate punishment in this case. And you can consider, in deciding this punishment, Travion's upbringing, what happened, his background, how he grew up, and his mental health history. As we talked about, the law says you can consider all of that in deciding his sentence. But beyond the law, our own common sense, our own experience says that what happens in a person's life when they grow up, what happens in their family, it matters. You know, during jury selection, I'm sure you all felt that both sides asked you every possible question that could possibly be asked. There's one question that used to be asked that was in jury selection that we did not ask you. And that's, who would you say is the most influential person in your life? That's because I think we all know that the answer for almost everybody would be a parent or guardian. As a group of people, we all have different life experiences. But one thing that I think that most of us are fortunate to have is a father or a mother or a guardian who loved us, who protected us, who helped guide us into becoming who we want to become. But look at who had the role of doing that with Travion and shaping who he was. You saw his mother, you heard testimony about what that was like growing up. You've read the DSS reports. She was using drugs. She was putting alcohol in her baby's bottle. And no, not every parent does that. And she completely neglected him. Now, as you've heard from from Travion's half-brothers, Corey and Aaron, and they are doing remarkably well now. And the question has been raised, if they could succeed, why could not Travion? Well, both of them deserve credit for their own success, and it's incredibly admirable how much they have achieved and everything else. But both of them, it's important to remember, went from that situation living with their mom to getting stable and loving homes afterwards that gave them the way to overcome that. But Travion had no such luck. First he went from his mother to a neighbor, Laura Cannon. But we know, from what we know about her situation, it was just as dysfunctional. In fact, she ended up being murdered by her husband shortly after Travion left. Some signs about the dysfunction that was going on there. From there, he went to stay with his father, Michael Clark. Michael Clark was not the one to provide him with the love, the guidance, with the protection that we all need. He is the man who physically, when he found out that Travion's mother, Antoinette, was pregnant with Travion, beat her and punched her in the stomach. He is the person who physically, mentally, and emotionally abused Travion. And when Travion was on trial for his life, his father refused to testify.
Objection.
Sustained.
It is in evidence. Mr. Love testified to that.
Sustained.
Sustained. And he cussed out his daughter when she said that she was going to testify about what went on in that family. But you know what may be one of the saddest things is, despite all those problems with Michael Clark, he was the only one that Travion had. Isn't he dumb? His mother wasn't there. Witnesses testified they barely ever saw his stepmother. Yes, Michael Clark may have seemed disengaged and seemed to he often sabotaged the efforts to help Travion. He was the only family member, though, who was there. These providers and caretakers, these teachers and providers had virtually no contact with his stepmother, and no contact with anybody else. Michael Clark did not provide Travion with the type of love, support, and guidance any child needs, but nobody else did either. We have heard that Travion had serious mental health problems and that he did not get the type of long-term treatment that both Dr. John Blackshear and Dr. Anne Marie Evans believed he needed. Sometimes he didn't get the treatment because, quite frankly, his family did not have the money that was needed to be done. And that is unfortunate in itself. But occasionally, he did get into a program where they did have funds and where he began to show signs that he would succeed. People began to see improvement in Travion. They began to see the good in Travion. And when that happened, his father, for whatever reason, would inevitably withdraw him from the program and, in fact, sabotage any hope he had for success. Ms. D earlier talked about the fact that his father kicked his son out of his home and exposed him to prison back in 2013. Of course, Michael Clark had the right to do that. Travion did not, the law did not require with Travion at that point being 20 years old that he didn't have to keep him in his house. But why, what would it cause a father to take the step to kick his son out of the home so he would be exposed to going back to prison. I'm sure everyone has a limit, but what was the limit in this case? Travion wanted to bring his child to the house for the weekend, and Michael Clark wasn't convinced that it was really Travion's son. Travion wanted to care for his baby. That was not the Michael Clark way. Michael Clark would rather have his son go to prison for a parole violation than have to help feed and home his grandson. Last Friday, the state had its last opportunity to present its rebuttal evidence. It was the last time for to present evidence about why Travion should die as opposed to spend the rest of his life in prison. And they talked about, in this, Travion's record, probation officer, and problems he had in jail. But with the state, and the state has shown definitely that Travion has problems and some difficulties. But what the state has not shown in this entire case, and did not show it Friday, is that Travion is beyond redemption. We heard that he had been in prison, and he was in prison for the crime of possession of a stolen motor vehicle. That's all you heard. That's his prior felony record. And as horrible as what happened in this case was, Travion is not someone who has a long history of great and serious violence, who has a long history of seriously hurting people, that the only way to control him is to put him to death. It's just not Travion. And they presented evidence that Travion misbehaved in jail. The state found in the 2.5 years that he'd been in jail 3 examples of misconduct. They included him refusing to go to his room and having to be maced about it, making smart and insulting comments to a guard, and getting into a heated argument with another inmate. A heated argument where no one was hurt. Now let's be clear about this. Travion was wrong all 3 times, and the jail was right for taking actions and punishing him for what he did. But we all understand that things happen in jail. And these 3 incidents in those 2.5 years do not show that he is so violent, so out of control that he cannot be controlled. None of those incidents show that the death penalty is necessary in this case. Nothing that you have heard shows that Travion is beyond redemption. What happened to Melissa Huggins-Jones was horrible, tragic, and heartbreaking. And I will agree with what was up there. It was completely senseless. And Travion will be punished for the rest of his life because of what happened. But his history before what happened does not show that he is incapable of redemption. His behavior in jail afterwards does not show that he is not capable of redemption. Travion's never going to be part of regular society again. But if his life is spared, redemption is still a possibility. You know, the testimony that you heard Friday gave us just a little bit of a glimpse of what Travion's life is going to be like from now on. Jail or prison has to have strict rules. And when Travion violated those rules, the jail took appropriate actions. We began to see a little bit of exactly what life in prison is like. Remember, the lockdown there started because an inmate had improperly changed the channel of the TV. and Travion failed to return to his room when he was ordered to do so. And he was pepper sprayed because of that. He got into an argument with another inmate. It was a heated argument, and he was put in 24-hour lockdown because arguments like that cannot be tolerated in jail. And that's what jail, that's like prison is like. You lose all freedom. As it should be, guards tell you what to do, when to do it, and you have to obey. Every aspect of your life is controlled. It is the tension of living that in prison with the not ability to do anything. Every aspect of your life is in the hands of prison officials while you remain behind bars. Prison, for most of us, simply sounds unbearable. It would be unbearable to go through it if it was only a week. But if you were in prison, but if someone was in prison for a week, he or she could bear it because they would know that at the end of the week, they would be getting out, that there would be a future, that there would be hope. If someone were in prison for a year, the fear, the tension, the loss of freedom would be unbearable. But he or she could make it through it because they know that at the end of the year, there's a light at the end of the tunnel. He or she will be getting out. If it were for 10 years, it's hard to imagine that situation for 10 years, but it would be how unbearable, how hard it would be, but at least that person would know at the end of the 10 years, as long and horrible as it be, there is a future, there is hope, there is one chance of getting out one day. So for Travion. For Travion, there will be no such hope. There will be no future to look forward to. He will wake up from prison the rest of his life knowing, I am in prison. I will always be in prison. And I am going to die in prison. For the last 3 weeks, we've heard a lot about the life of Travion Smith. We heard about the horrible events that happened in May of 2013. And last week, you heard a lot about what happened in those 20 years of Travion's life. And now, it is about the future of Travion. We know how that future, where that future is going to end. It is going to end in prison. Travion Smith is going to die in prison. Now you will decide how he will die and when he will die. Punish Travion harshly. Punish him severely. But punish him appropriately and with compassion. Sentence Travion to spend the rest of his life in prison. Thank you.
Thank you, Mr. Brown. All right, members of the jury, I'm going to go ahead and call a lunch recess for your benefit, and when you return, we will proceed with my instructions to you on the law for this phase, and you'll then be asked to deliberate. I'll ask you, unless one of you indicates otherwise, to return to the courtroom or return to the deliberation room at 2 o'clock. Either any of you have any plans over the lunch recess that would make that difficult for you? All right, if not, I'll ask you to return at 2 o'clock. All of the rules remain critically important. Don't talk about this case with anyone or allow anyone to talk about it in your presence. Don't form or express opinions about the outcome. No media or independent investigation. No communications with any parties, witnesses, or lawyers. Please leave your notepads in your chairs and again gather at 2 o'clock in the deliberation room. Everyone else, please remain seated. Outside the presence of the jury, are there matters anyone wishes to be heard on? I have one matter I need to bring to your attention. Anything for the state? All right. I was made aware during the state's argument that the Sheriff's Department had notified the District Attorney's Office of the possibility that a juror had been monitoring social media relating to the defendant's sister. And so I'd like to inquire into that, find out what that information is. For the purposes of this inquiry, I'm going to ask Ms. Love, who I see in the courtroom, if she would, I'm going to ask that she remain outside the courtroom in one of the conference rooms just outside so that we can get to the, so we can get a full understanding of the issues that might be involved in this matter. So, Ms. Love, thank you for waiting outside for us. Mr. Cummings, I see, is here from District Attorney's Office. Mr. Cummings, do you want to share with us the information that you have? And I understand that this was brought to your attention by a member of the Sheriff's Department, Officer Hart. So in any event, would you mind letting us know what information you have?
If I could, I would just ask Bill Hart to relate the information that he had that involves a person at a coffee shop down the street.
All right, very well. Perhaps, Mr. Hart, if you could sit here, if Mr. Wall, if you could move that television so Mr. Hart could sit there. Mr. Hart, I'm going to ask that you be put under oath for the purposes of this proceeding.
Place your left hand on the Bible and raise your right. Do you solemnly swear the testimony you give this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please be seated.
Mr. Waller, could you remove the easel as well?
Yes, sir.
All right, Mr. Hart, if you could just convey the information that you have, sir.
Yes, sir, Judge. It was probably about 9:15 this morning. I went over to coffee shop at the Sheraton. I can't remember, it's Cafe something at the Sheraton Hotel. And I go there regularly. I don't know the name of the girl, but she waits on me occasionally, and then she knows I work at the sheriff's office. And she asked me if I work in the courthouse, and I told her no, I worked in the actual public safety center next to the courthouse. And she started telling me about a friend of hers who, from what I gathered, was a juror in the case. I don't know that to be true, but that's the impression I got, was concerned about coming in today because of some contact that she had had on social media or some things she had seen on social media. And the gist of what I understood was that she may have seen some things that the defendant's sister had put on social media and had either commented on those or made some comment to someone about that, and that then the defendant's sister had put some things on social media about this juror, and that she was somewhat concerned about that and having to come into court today. And that was the term she used, social media. I don't know what type of social media it was, and I didn't ask a lot of questions. But as soon as I had gotten my cup of coffee, I went over to my office, and first thing I did was call the DA, Lauren Freeman, on my cell phone.
All right, and was there any description given of the juror that you believed was involved? Was it young, old, male, female, any description at all?
The girl at the coffee shop, I would say, is probably in her early 20s. She's a part-time student at NC State, and she was talking about this being a friend of hers. So I was under the impression that it might be a younger person, but I really can't say.
All right. And you've not had the ability to go into any of these social media sites and examine any comments that might have been posted? Have you?
No, sir.
You've not had the
No.
opportunity to do that or the ability to do that?
And I didn't do anything to go back and talk to this girl, or the only thing I've done is talk to Lauren and then talk to the deputy that you had call me.
Yes, sir. Thank you. All right. Any follow-up questions that counsel for Mr. Hart? I'll talk with you about perhaps what the next steps ought to be, but anybody feel that there's further information that we need from Mr. Hart?
I mean, Your Honor, I don't know that Mr. Hart has an answer. He said that his vague impression is that it's a young person. I guess the only other question would be, does he have a vague impression whether they're male or female? But
I asked that, but I don't think you're just speculating that it's a young person because it's a friend of the young person with whom you were interacting.
Again, I didn't ask a lot of questions, and I tried to think back to see if she used the term she, but I can't be certain that she did.
All right. And Ms. Shakita, and you say she works at the coffee shop down at the Sheraton, is that correct? All right.
And they only go till 11:30 each morning, and she will also be working there tomorrow morning, but she works in the evening some at the Sheraton, I know, but that's all I know about her.
All right, very good, thank you. Ms. Shakita.
I was going to tell you, Your Honor, after getting this information and speaking with Ms. McGovern, I think that she can shed some light on the concern.
All right.
And so I'm sure she's glad to come back up there if Your Honor would like for her to do so.
All right, yes. Ms. McGovern, do you have further information about this matter that you could share if you want to? Thank you, Mr. Hart. If you want to
Yes,
step
sir.
down, sir. Ms. McGovern, if you want to step around here. And let me have you placed under oath for the purposes of this inquiry as well.
Yes, sir. Hold down the Bible, raise your right hand. You solemnly swear to testimony you give this court shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, ma'am.
All right, Ms. McGovern,
Yes.
what information do you have that you could share with the court about this incident?
I also work at the Sheraton. I was there this morning and I got a coffee from my friend. I don't want to say her name. I believe she's talking about me, and obviously I'm not a juror. And over time throughout this trial, we have talked about this. I've only talked to her about information that has been open to the public, what has gone in the trial room. I've not talked about anything confidential. And she also has been following along with the case.
Okay, so this is someone, and did you speak with this friend of yours this morning?
I did. I got actually a coffee from her from Cafe Sienna is in the
All right,
Sheraton
Cafe
Hotel.
Sienna is the name of the coffee bar. And generally, did you have conversations this morning about the case?
Yes, we did. Said I was going to court this morning. And what happened on Friday with the Miss Love and the Twitter, she had just said, "Are you scared of seeing her today?" And I said, "No."
I see. All right. Well, that certainly is an explanation of what may have occurred. All right. So based on that, Ms. Shakita, are there any follow-up questions that you would suggest for Ms. McGovern?
At some point, this girl that you know from the coffee shop Did y'all have a conversation about a different type of social media other than the Twitter information?
Yes,
And
Snap.
can you tell the judge about that?
Snapchat. I know another coworker who knows Miss Love. They had worked together previously, and she also knows that I'm an intern here and that I am on this case. And she has her on Snapchat that had said, "Can't wait to be on Monday. Can't wait to be in court on Monday," and other. Yeah.
All right, so that would be, okay, let me make sure I understand the connection here. This is another coworker of yours at the Sheraton
Yes.
who follows Miss Love on Snapchat.
Yes, I think she said after she had seen that, she had taken her Snapchat down. But
And
she was, I'm sorry, she was confused like why she was saying that stuff. And then when she had found out the next day I was testifying against that, she said that all made sense now.
all right, all right. So this is just simply information that Miss Love was posting on a different social media platform that you don't have access or the ability to follow because you're not
A
a friend
Yes.
on that platform, but a third coworker or another coworker does and said that there was a comment.
Yes.
on-
They had
about
worked
that.
together previously.
All right, all right. Okay. Any further questions that you would,
Just to be clear, Ms. McGovern, have you ever talked about this case in front of any of the jurors?
No.
Ms. Brown, Ms. D, do you have any further inquiry?
No, sir.
All right. Okay, thank you, ma'am. There certainly, as many times as I've warned the jury about communicating in any way whatsoever with any parties of witnesses, I would certainly surprise me if a juror did not understand the gravity of that sort of communication. So this certainly is an explanation that seems plausible. There are a couple things we could do. One, we could inquire with Ms. Love about whether she has had any communication with anyone that she believes to be a juror in this case, or I'm not sure. Since she is simply posting things, I'm not sure that she would know whether anyone who's on the juror has viewed that, or so that certainly would be one area of inquiry, and I'll say that Ms. Love certainly has the right to discuss this case if she chooses, so long as it's not in violation of any of these court orders, which certainly communicating with the jury would be. The other thing that could be done is we could track down this individual who shared this information with Mr. Hart, inquire with that person as well. It sounds like we at least may have a name, may be able to track that person down this afternoon. If not, I could do it tomorrow morning when she reports for work. I'll hear from counsel as to your views on how best to proceed under these circumstances. Yes.
Investigator Jerry Winstead has tracked her down and spoken with her, if you would like to hear.
That would be helpful.
Thank you.
Yes, sir. And you can be sworn as well. And
Do you solemnly swear the testimony you give this court shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, sir.
Investigator Winstead, if you would tell us what information you have.
After speaking with DA Lauren Freeman this morning about this, I went down to this coffee shop at the Sheraton and inquired about it with the young lady working at the counter. I did identify her name, and I can identify her to the court if you wish. And the urgency to get down there to talk with her was she was getting ready to get off shortly this morning. So I actually talked with her a little bit before 10 o'clock this morning. And everything that that young lady just told the court was pretty much the same thing she told me.
Ms. McGovern just explained to the court.
Yes, sir. Yes, sir. Pretty much the same thing. And the young lady basically said that she had not had any communication with any juror, didn't know any juror, that the only person she knew related, anywhere closely related to this case was the young lady, Grace. And that they had just general conversations about it, nothing specific at all. And that was pretty much all that she told me about her involvement in the case. And she did say that she had been talking to Mr. Hart some throughout the week, and this morning in particular.
All right, thank you. Any follow-up questions for, and Mr. Brown and Ms. D? All right, thank you, sir.
Yes, sir.
All right, well, based on this information, I think that is really no evidence that that there has been an improper communication with jurors or monitoring of any social media sites by a juror. I think there was an initial misunderstanding that has been cleared up, I think, to the satisfaction of the court. I'm inclined to simply leave this issue as it is and not take any further action. Ms. Shakita, Mr. Waller, do you wish to be heard on that? Mr. Brown, Ms. D?
No, sir.
All right, that's what we'll do. If you will thank Ms. Love for remaining outside available, but I don't see the point in even discussing it further with her, so.
Other than maybe, someone to show her that she's not in any trouble, given how scary it might be if you, other circumstances and all. So that.
All right. All right. Ms. Love, thank you very much for waiting outside for us while we dealt with this matter. We appreciate it. There's no further need to inquire of you, ma'am. All right. With all of that being said, if there's nothing else, then we'll simply be in recess until 2 o'clock. And I have printed out copies of the instructions. The only change I've made is, do you have a copy? You do not have copies of those, but I had referenced in the elements of a robbery, the Victoria's Secret jewelry box. I have taken that reference out and left it simply as taking and carrying away items. I did not specify any particular items with respect to that. That's the only substantive change I made in the instructions. All right, with all that being said, then we'll be in recess until 2 o'clock. Yes?
What did you decide about the expert witness?
I've included the expert witness, yes. In fact, I'll give you printed copies of those. Instructions now. And you're free to review them, but I did include the pattern instruction on expert witnesses that was given previously and just simply included that as well. All right, very good. Thank you. We'll be in recess till 2 o'clock.